Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to learn a case law decided by the Honorable Supreme Court of India that if the promise of rape and consensual sex took place and if the promise fails, it cannot be attributed as a rape. So this is what is held by two judges bench, Justice Sanjay Kishan Kaul and M.M. Sundaresh, while deciding the case of Mandar Deepak Pawar versus State of Maharashtra in Criminal Appeal number 442 by 2022 on 27th July 2022 held that when the parties chose to have consensual sexual intercourse, maybe the physical relationship may be under the promise of marriage, and when they had the relationship without marriage for a reasonable time and it fails, or if they fall apart, she cannot file a case of rape. So a breach of promise cannot be a rape. A breach of promise is definitely it's a breach, that's all. So you can go for civil remedy, you cannot term it as a rape. So this is what is held by the Honorable Supreme Court of India. Right. Now we'll go to the facts of the case. So this relates to a complaint regarding 376 and 420. 376 is rape, 420 is cheating. Actually, as police officers, we booked a number of cases like this during our tenure, right? So both parties were admittedly in relationship or consensual sexual relationship from 2009 to 2011. No doubt. In the meantime, the so-called male partner, he refused to marry her. Both of them fell apart. Please remember, fell apart, and she kept quiet for about 5 years or so. And in 2016, on 16/12/2016, she gave a report and this was registered as an FIR under section 376 and 420 IPC. Right? So please remember, in this connection, this man, that is Mandar Deepak Pawar, he approached the Honorable High Court of Maharashtra, stating that it is only due to her mistake or due to her dispute, or since she fell apart from him, she has parted ways from him, he could not marry her. But she says that he did not fulfill the promise of marriage. So anyway, so he wanted for quashment of the FIR against him. But Bombay High Court did not agree. You know, the Bombay High Court stated that rape is an offense against society. So please remember, they will not allow the FIR. Ultimately, they filed this appeal before the Honorable Supreme Court of India. Now Supreme Court placing reliance on a very beautiful case. I will tell the case. So the registration of the FIR is nothing but abuse of the criminal procedure or criminal policy. Right? This falling apart or dividing or failure to marry may take place before the marriage, even after the marriage also. So many ways it happens before or after the marriage, in so many ways. So in this case, the Supreme Court relied on the famous case Pramod Suryabhan Pawar versus State of Maharashtra 2019. In this case, the Supreme Court stated that when the complainant is aware of the hurdles for marriage because elders did not accept, this fellow is not a person, he is a person who is not staying on his words or promises. So keeping ahead or knowing all these hurdles, she continued the relationship. So therefore, it's only a breach of promise, right? So in this connection, Supreme Court discussed the provisions relating to section 375 explanation 2 and also section 90 of the Indian Penal Code. 90, you know about consent. So while dealing with the general exceptions, we will be telling you about the section 90. So section 375, as regards the consent, Consent must involve an active and a reasonable, deliberate activity toward the proposed act. Not only saying, yes, I agree. It's not that. She has to participate. She has to be active. That is only the consent. Yes, here the consent is given. Secondly, Section 90 of the Indian Penal Code, it says consent given under misconception or misconception of fact. Here, what is the misconception of fact? That he promised to marry. So, when he is going to be husband, she surrendered herself. So, that means it is nothing but a misconception of fact. And this consent is not at all a consent. It is deemed not to be a consent as per Section 90 IPC. Consent involves submission. Already I told you, I don't want to explain more. Consent involves submission. So, Section 90 is a negative in terminology. So, please remember, mere act of submission. So, it amounts to consent. Therefore, since there is a consensual sexual relationship between two parties and this fellow failed to fulfill his promise, it cannot be called as a rape. There are other provisions of law. You can file a case, but not under Section 420 and also 376. This is a good decision by the Honorable Supreme Court of India. Please read it and enrich your legal knowledge. Thank you very much. Sorry. ఏం పాపట్లేదు.